Welcome to SB&M is Here, the State Bar of New Mexico's official podcast. In this series, we'll discuss topics such as professional development, tools of the legal trade, and mental and professional well-being. Connecting the legal community across New Mexico, SB&M is here. Hello, everyone. Welcome back to SB&M is Here. This is Morgan Pennant, Member Services Manager and Podcast Producer. For this episode, we'll be hearing from our Lawyers Professional Liability Insurance Committee, or LIPLIC as we more commonly refer to them. They'll be chatting about common ways lawyers can get themselves into trouble, malpractice carrier concerns, red flags with clients, and some general recommendations to avoid potential professional heartburn down the line. One of my favorite takeaways from their discussion was in for a penny, in for a pound. So I'll let them explain that a bit more. And Bill Sleece, feel free to take it away.
Thank you so much for that introduction, Morgan. We appreciate everybody listening in today for what we hope is going to be a great talk on reasons why lawyers might find themselves in a bit of trouble either with the disciplinary board or in a malpractice claim, or sometimes, unfortunately, both. My name is Bill Sleece. I'm the Professional Practice Program Director for the State Bar of New Mexico, and I'm joined today by Ben Davis and Jeannie Hunt. I'm going to let them introduce themselves.
I'm Ben Davis. I am a trial lawyer. I handle typically legal malpractice for the client and prosecute legal malpractice cases pretty regularly against lawyers in New Mexico, as well as I have some out-of-state cases as well. So that is primarily my area of practice, is legal malpractice as well as medical malpractice.
And Jeannie, tell us about yourself.
I'm Jeannie Hunt. I work with Jack Brandt, and we do primarily legal and accounting malpractice defense. I have been with Jack for, almost 10 years.
Great. Well, our hope today was to have a little bit of talk based on your experience with the kind of things that you see that cause lawyers to have some sort of entanglement with the disciplinary or the legal malpractice system. And let me preface it by saying we're not offering these as statistically based or anything that carriers have said, here's what causes us to stay awake at night. It's really based on the experience of our panelists here and their observations, but both serve on the Lawyers Professional Liability Insurance Committee, and that's a group that spends some time thinking about these topics, have a vast collection of wisdom and experience on these topics. And so I think the information that you're going to get today should be pretty well based in a lot of experience that our panelists have. So let's just start. I know that years ago, your partner, Jeannie, Jack Brandt, actually had written an article that talked about the top 10 ways, and I don't know that we necessarily need to stick to 10 ways, but let's just talk about some of the common ways in which lawyers can get themselves in trouble. And I'll start it off by just asking you guys, what about the lawyer who, for lack of a better term, decides to dabble or doesn't stay in their lane? What do you guys think about that? And what do I mean by that?
I think what you mean by that is a lawyer who is primarily practicing in X, but maybe has a friend who needs a divorce or a bankruptcy or fill in the blank. And they think, well, that's not hard. I can do that. Dabbling outside your area. The famous last words, right? Well, that won't be too hard. How hard can that be? Yeah. The answer is very, don't do it.
Yeah, I see. And again, just based on my experience, what I see a lot is malpractice occurring was where folks, perhaps they're a criminal lawyer and they get in a personal injury case, or they have a specialty, they know how to, as you say, stay in their lane and do that type of work, but maybe a former client or a friend or someone brings a case that, looks lucrative. And inevitably, I think it causes problems when they don't do what the disciplinary rules require and professional rules of conduct request us to do, which is bring in someone who, it's not, you can't take the case, but you need to bring in someone else to help you with the case who has more experience in that area. And sometimes you can't take the case. Sometimes you just do need to refer it out, but you have to look at those rules. And that's really, I think, where we see, I see a lot of problems, particularly And then also they just get into stuff that they don't even know they're getting into. I'll give you an example is securities work. I think I've seen transactional lawyers just all of a sudden not even appreciate that they are doing securities work. And not security, I don't mean security like securing a building or anything like that. Securities work, blue sky laws, that type of stuff, SEC stuff. And boy, it's just so easy to all of a sudden find yourself in a world of hurt because you just don't quite understand what you're involved in.
Right. And it's not even so much that we're saying lawyers can't take cases that are outside their normal practice area. Of course you can, as long as you spend the time to get up to speed. But what I'm hearing from you two is maybe sort of two common reasons. One, once you start practicing outside your normal area, or once you start dabbling. One is not even having the basic knowledge to know that you're outside your lane into areas that are really complicated. And I think you mentioned, for example, security law practice, Ben, or maybe they get into some complex tax issues and don't even realize that those issues are there. And then Jeannie, you touched on the other one, but I heard you say it too, Ben, doing something for a friend, right? And it's that common thing where you just think, well, it's going to be a quick in and out. I'm going to help somebody out because they can't really afford a lawyer. And then all of a sudden it's much more complex. Plus, sometimes those clients are a little less patient and a little less grateful when you're doing them that great favor, which kind of leads to an additional issue. I know that Jack pointed it out in his article, Jeannie, is the just helping out notion in general. What's that about?
I think that comes up in a lot of different iterations, maybe like local counsel. I'm going to pop into this case and just do XYZ. I'm just going to defend this deposition. I'm just going to attend this hearing, whatever. Or also just kind of assisting, somebody needs a little bit of help with this. So I'm going to hop in and I'm going to help out my friend. I have a really interesting war story about that. And I'll just say before I start that you need to be really careful. You can do that. You can serve as local counsel. You can sure help your friend. But the ethics rules, Bill, and correct me if I'm wrong, I think say that once you are in a case, regardless of your role in that case, however limited it may be, you owe the very same duty to that client that the lead counsel does. So if you're going to come in and take a deposition, you owe the same duty of care and competence and diligence to that client that their lead attorney does. So you just need to be really careful and make sure that you trust the person who's bringing you in and you have done your research and you know your case, because you're going to get pulled in to a malpractice case. And here's an example. I had a case a couple of years ago where lead counsel was a good attorney, gentleman, and he had a corporate client. Corporate client had an arbitration scheduled on one day, and lead counsel also had trial that same week. So he was double booked. So lead counsel calls up a couple of his friends and he says, hey, can you do me a favor? Can you cover this arbitration for me? This is what we're going to do. This is the strategy I want you to employ. Go in, do this, say this, and that's what we're going to do. So his friends did that. They went in, they did exactly what lead counsel told them to do. And the arbitration award against the corporate client was millions of dollars. So of course the corporate client sued lead counsel and then also sued the friends. And it was just a big mess for, helping out on one day. So just be super careful if you're going to do that you are up to speed, and those friends are on the hook because they should have looked at the strategy and they should have said, ooh, maybe this is not the best idea. So just be really careful if you're going to go that route.
Yeah, and I think it kind of goes to the whole idea, Jeannie, that your bar card is your bar card, and so the idea that someone else gets to tell you what to do with that bar card is not okay, and so you do have to make that independent judgment. The local counsel gig is also it is fraught with risk, I think. I mean, what I have seen, just again in kind of war stories as well, is I saw a case where It's still ongoing, actually, but it's some Texas lawyers were involved. There was a local counsel here. The Texas lawyers were totally bare. They had no insurance. The local counsel did have the insurance, and guess who gets pulled into the case? That kind of thing happens. And I'm not sure. I'm licensed in Texas and went to law school in Texas, but they seem to be a little bit looser sometimes with insurance, I think. And that's another thing to think about when you're getting into a local counsel gig, is making sure that they have insurance and that it's up to date, and that you can check that insurance, from time to time because of renewal periods and things like that. And even I do co-counseling with other folks. That is part of my co-counseling agreement, is that, the other counsel is also going to carry insurance, and that I can check that and all of that type of thing. So I think that's very, very important, is to think about who you're working with, make sure they're insured as well. And then, like you say, make that independent judgment as you move forward throughout the case.
Well, and it's not that necessarily you guys are saying that lawyers can't limit the scope of their representation. You can do that under 16102
Sure.
in New Mexico. You write a really good letter, write a good agreement. But that's not what happens in these cases. That's not how they unfold, right? What you're talking about, Jeannie and Ben, you're going to jump in just for that one matter, but of course you don't write that limited scope representation agreement, and now you're co-counsel in the case, and in for a penny, in for a pound.
That's
and
right.
It's what you guys are saying. Now you're on the hook for everything, and you're exactly right, Jeannie. Every duty is triggered at that point because that's your client. And to Ben's point, absolutely, you become a great looking target if you're the only one who's insured. Maybe not the only target, but certainly a prime target if you've got insurance. And so I think those are great points. The other thing, and it kind of touches on that first issue that we talked about, is maybe somebody's calling you out to serve as local counsel on something that you're not experienced in. And that, in my mind, raises a question. Ben, you maybe can speak to this. If you're getting outside your lane, if you're serving as local counsel on something that you really have no competence in serving on, is your malpractice carrier going to potentially tell you, hey, we didn't rate you for that?
There is, yes, that is a real possibility. Absolutely. As we all know, we fill out these applications every year. You need to identify for your carrier what type of practice you're in, because those different practice areas have different, as you say, ratings. They're going to price your policy, your premiums on those types of practices, because some practices, frankly, don't have a lot of risk to them. They just don't have the risk that other practices do. And the one I keep going back to is the security stuff, because that is such a specialized practice, and it often results in litigation. And so carriers are very reluctant to. There are some carriers that won't even dabble in that area. They won't even underwrite any type of policy that deals with security. So if you're doing any type of securities work, tax work's another one of those types of things. My firm, we do, primarily plaintiff's work, litigation for, medical malpractice, personal injury. That's another type of area of practice that I think gets rated riskier because there's just statute of limitations issues and a lot of other things. So we probably pay a higher premium for our policies than a lot of other folks. So as compared to maybe just a civil defense firm that's litigating. So there is something there. If you get out of your lane and you haven't told your carrier this is the kind of work I'm doing, then yeah, I think they absolutely may have the ability to come in, file a deck action against you, and say, hey, we're not covering that. And so if you're a lawyer who does a lot of local counsel work that's perhaps outside of your practice area, I think you have to identify it on your application.
Yeah, and it also leads to sort of a second question about what local counsel actually means, right? The other risk, Jeannie, is the local counsel who truly is just the mail stop. Not were you doing just maybe the one deposition that got you in trouble, but you agreed to take a small percentage, so you could serve as the local stop because that lawyer didn't want to PROAC in or didn't want to get licensed in New Mexico. Tell us a little bit about those risks.
Well, say that again, Bill. I'm sorry, I lost my train of thought.
No. It's the lawyer, and I think especially a risk for newer lawyers to practice. So newer to practice, where you've got the out-of-state lawyer who doesn't want to pro hoc into New Mexico, doesn't want to get their license here, but you know what? Jeannie Hunt, we'll call on her and we'll throw her a few bucks and she'll serve as our local counsel. What about the risk there?
There's a huge risk there because, again, you're certainly allowed to limit your representation. You're certainly allowed to write a fantastic engagement letter that says, this is what I'm going to do for you. You're certainly allowed to file an entry of appearance that says, this is what I'm going to do. I think, and in federal court, I think the local federal rules require that if you're going to file a limited entry of appearance, that has to be approved by the court. So you need to make sure that you're following the rules. But then again, even if you are just the mail stop, you have the very same duty to that client that lead counsel in California or Texas or whomever does. And I actually have a case that's ongoing. There was California counsel. They filed the case here. They needed New Mexico counsel. California counsel didn't pro hoc in. California counsel, I believe, failed to bring in a party that should have been a party to the lawsuit. And of course, California counsel gets sued and New Mexico counsel gets sued, even though New Mexico was just, we're just here to defend depositions. The California counsel, they're the lead counsel. They're the ones that are making the decisions. That just doesn't work. I mean, I'm logically, that makes sense. This was my role. And this was California counsel was lead counsel. That was their role. But that's not going to get you off the hook in a legal malpractice case. I mean, you are on the hook. Like you said, Bill, in for a penny, in for a pound. You have the same duty. You need to make sure that the parties are brought in that need to be brought in. So you need to be really careful.
And even maybe more so in that case, right, Jeannie, because now you're not making any of the decisions. Mm-hmm. Somebody who's out of state, and as Ben said, who's holding maybe a different looking bar card than you, is calling all the shots, and yet it's your license, your bar card that's standing up to make it right in our state, and you've got no control, no decision making, no nothing. You've got all the risk and really very little of the benefit or the gain or the control in the litigation.
And it's very hard to defend you if your defense is, they didn't tell me to do that.
Right.
And I think you can also get crossways, right? Sometimes in these types of cases where the fingers start doing this, right? The California, like in your example, Jeannie, the California firm starts pointing the finger at the New Mexico firm saying, well, we didn't know that was the rule in New Mexico, or, that was your job kind of thing. And why didn't you alert us to this? So I certainly could see how that could happen in a situation like that as well.
Right. Now you've built in a defense for the out-of-state firm because they're saying, hey, we paid you to tell us what was going on locally. What do you mean you didn't have any decision?
Yeah. I relied on you.
Right. Yeah. Exactly.
Let's switch gears a little bit and talk about some of the client-related issues that sometimes get lawyers in trouble. And of course, the first one, and it's something that probably all three of us heard early on in our practice, is look out for those red flags. What kind of things should you be watching for when a client comes through the door that makes you think, boy, I don't know if this is going to be worth it?
I'll let Ben do that one.
Yeah, that's probably certainly learned over the course of my career so far. There are all kinds of signs, but I think what I've seen is I am the fourth or fifth attorney they're on at this point, or they want to make me the fourth or fifth attorney. I will say that they usually don't get to do that, but that is certainly one of the things. They've either fired the other attorneys, or the other attorneys fired them is oftentimes what happens, but we don't get the full picture. What scares me, and I've seen this a lot, is they have an attorney. They haven't fired that attorney, but they want to get my thoughts on something. Should I take this settlement, for example, is a classic one I always see, or I'm like, at that point, hit the brakes. This is your attorney. I can't speak to you. You need to talk to them. If you want to terminate their representation of you, you're certainly allowed to do that, but you have to go do that kind of thing. But again, it's one of those types of cases where if they're doing that is not a client I want. That is a massive red flag for me. I'm just not interested. What happens sometimes is I don't often see it necessarily in the initial kind of meeting, but the client who is calling every day, and I, to protect myself, and again, I think you can see, we'll probably get to this. Attorneys that don't return phone calls are attorneys that can get sued quite often. So I'm an attorney who returns phone calls often and regularly. You're not going to make a phone call to me if you're my client and not get a phone call back. So, but there comes a point where it's just over and over and over again, and despite trying to allay their concerns, it doesn't get better. Some of that, quite honestly, sometimes, particularly in legal malpractice cases, I see this a lot, and I've learned to be patient with it because you just have to. Oftentimes, my clients have been harmed by another attorney, and so perhaps they were pretty passive beforehand. They are not so passive now, and because they're worried their passivity perhaps caused this problem, and so there is a trust process, I think, that we go through, that I go through with some of these clients, to where they have to build trust with me so they can let go of the reins a little bit and let me take over the case. So that's a little bit different than what I'm speaking about, which is a client who is just can't build that trust with you. And frankly, if they can't trust you, and I'm going to have a hard time trusting them, and it's just not a case I want to be involved in. So that's just another red flag.
That high needs client.
I'm sorry?
That high needs client, right?
Yeah, exactly.
The really needy, always touching base with you.
Exactly.
Let me ask Jeannie this question. I mean, I know you do primarily the defense work, and so a lot of your clients come to you through insurance companies. But what about the clients, especially the professional clients, or maybe any client really, right? A lot of anxiety, a lot of expectations about what you're supposed to do and not supposed to do, and they want to direct litigation. Any signs there that you need to be concerned about?
That actually happens pretty frequently. A lot of times attorneys are, offended, and kind of rightfully so, that they have been sued. Some lawsuits we see, never the ones Ben brings, but a lot of the lawsuits we see are just an irritated client. I got X in settlement and I should have gotten more. No, that attorney did a great job for you. And now you just, you have a bee in your bonnet about something. But attorneys tend to be, at least that I have seen, they tend to either be pretty laid back, pretty like, yep, that's why I have insurance, it's okay, whatever you think. Or they tend to be more involved. It's their license on the line, or their business, or their livelihood, their reputation. They want to make sure that you're taking this seriously. And I completely understand that. And I've had some clients that will say, no, we need to do it this way. And you just need to politely tell your client that, that's a great idea, and maybe we can revisit that later, or that's a not good idea for XYZ. It's my job to defend you. I promise I'm doing my best. This is what I'm thinking, and this is how I think we should go. I mean, I think it's really natural to want to defend, to want to take an active part in your defense, because it's your career, right? It's your reputation. But you do need to trust that we are doing our best for you, and we do this for a living, so we know what strategy is going to work and what isn't going to work.
Which really kind of segues us to the issue of what I'm hearing both of you talk about is managing expectations, right? As a way of reducing your risk of a client being dissatisfied after the fact. I mean, Jeannie, you mentioned the unhappy client after the fact because they just felt like the lawyer wasn't doing what the lawyer, quote, should be doing. Ben, you mentioned the really high needs client, the client who's calling every other day. That's really about managing expectations, right? How maybe both of you can just spend a minute, because I think that reduces the risk to the lawyer of getting sued or a disciplinary complaint. How do you manage the communication, manage the expectations? Ben, you talked about clients are going to get called back, but if you've got the client calling 20 times a day, you got other stuff you got to do. Maybe a little bit, both of you, about how do you manage expectations in an appropriate way? I don't mean that condescendingly. I mean, how do you set realistic expectations for your clients so that you don't have those communication issues later?
Mine starts with a fee agreement, because oftentimes what I see is, and in fact, this happened to me early in my career, and it did. A client had a misunderstanding about how a fee agreement worked, and I do a lot of contingency fee work, so that's critical that they understand how that works. And so I actually I get complaints about this from other lawyers. My fee agreement's about 6 pages long. And part of the reason it is because I try to explain in plain English, and I go through it with every client, each paragraph, explaining all the different issues that can arise as we go through this process. And one of the things I do is first of all, I outline, the contingency fee and how that works. But then I go through a hypothetical in my fee agreement, so they understand, this isn't your case, but if it was $100,000, here's how my fee would work. Here's how gross receipts tax would work. Here's how the expenses come out. And if there is subrogation, medical subrogation, like a personal injury type of case, this is how that works. And this is the amount you would receive. And that, when I started using that, and it happened right after this client that we had just a misunderstanding, frankly, and it went to his benefit. The misunderstanding did, of course. So, after doing that, addressing those concerns and addressing that understanding right up front, I have never had an issue, knock on wood, with a client misunderstanding how it works at the very end of the day when I'm providing a closing statement. And also in mediation, I'm doing the same thing. For example, if numbers are going back and forth, I am there with a spreadsheet and I am showing them I'm getting costs from my bookkeeper. We're going to be within a few $1,000s of this number in your pocket. So this is what this means. It doesn't mean, $500,000. It means $325,000. Just, I'm just giving examples, of course, but I think that is the best way to manage expectations. I also have that discussion because I think everyone probably, I'm sure Jeannie does too, there's no guarantees of success, right? This is trial work that I do, so there is definitely no guarantees of success. We win, we lose. And I have that explanation as well at the time of the fee agreement signed, is that I win cases, I lose cases. I cannot tell you what's going to happen with your case. Mm-hmm. I wouldn't take your case on if I didn't think it was a winner, because I wouldn't be paid. But that being said, I have no idea what's going to happen with 12 men and women who I don't know. There's just no way for me to tell you one way or the other. So I think the key to all of this is effective communication is really the best way to manage those expectations.
Yeah, and early, right, Jeannie? What I hear Ben talking about is from the get-go. The time to have those discussions is not when the client's expressing some discomfort, upset.
Right, I absolutely agree with Ben. And on my side of it, you need to do it immediately. The insurance company will, 30 or 60 or 90 days out want your impression, and you need to be brutally honest. You need to say, these are the problems I see. This is where this client, you don't say fell down, but, fell down. These are the things that probably should have been done that weren't done. These are the things that were done that shouldn't have been done. And that needs to be done early, and it needs to be done often, because what's going to end up happening is your client's going to say, well, I didn't know that. I thought, I've had plaintiffs, I've defended cases where the plaintiff's like, well, he never told me that. He didn't tell me we were going to lose. Well, duh, of course you're going to lose. There's always that risk. So you need to do it. You need to do it often. You need to be really honest. I know your client doesn't want to hear that they may have messed this up, but, you need to tell them, because it helps manage, and when we go into mediation, you need to know that this is what the other side is going to say. This is what the mediator is going to say. And, this is something that we're going to have a really hard time defending against, or in some cases can't defend against. Here's the issue. You need to, like Ben said, paper the file. Just, confirm conversations when they ask you anything that is substantive at all, confirm it in an email. And then please save your emails. Save not only the emails you get from your client, but the ones that you send to your client as well. Please save that, because inevitably what will happen is your client will say, well, I didn't know that. They didn't tell me that. And I can pull out an email that says, well, they did actually see on this day, and you got it and you responded. Another thing I would say is mediation statements. You can write whatever you want to the mediator, but you need to be sure that you write to your client a separate letter that says, hey, I wrote this great argumentative position paper to the mediator, but I need you to know that here are our weaknesses in this case as well. And just like Ben said, I don't know how it's going to shake out, but I need you to know that while we have these great facts, we also have these problems too. And this is going to impact what happens in the case.
Right.
Yeah, I was going to say, I think you make a great point about mediation. That's the other thing is to effectively communicate well prior to mediation. I mean, there should be, even if it's just a phone call meeting, not just for me, sometimes I have, clients that don't, unlike Jeannie, you represents lawyers. Oftentimes I'm representing clients that may have not experienced a mediation before, or if they did, they were represented by a lawyer who didn't really kind of explain the process. They had no idea what was going on. So the process part of it's important, but the substantively, it is just, you need to have that conversation. Here's where they're coming at, and there is no such thing as a perfect case. Never had one in my life. I doubt I'll ever have one. It's just not going to happen. So regardless of how strong the client feels, and on my side of it, I often get, well, I believe in you and I think we can do this. I am very glad that you believe in me. I'm very glad you believe we can do this. That is all important. But let me just continue to tell you that this risk is real. 12 men and women who we don't know may see it differently than you do. And so those conversations early often are very important. And frankly, I try to have good relationships with opposing counsel as well, because sometimes I don't see their defense. And I sometimes will just call opposing counsel and just ask them, listen, this is not going to end up in a pleading, but where are you coming from? Give me the defense. So I got a better idea how to advise my client. And I for the most part, I think a lot of defense lawyers will do that. And I'll do it with them as well, because sometimes they can't see my case. They'll say, boy, this seems like a crazy case. What are you doing? And it's helpful for me to, be able to convey that theory of the case to them in an effective way so they can advise their carrier or their client what they're looking at.
Yeah, and so what I'm hearing from both of you, it's a matter of not just communicating early and ongoing and often, but being able to bring that bad news to them and not just putting on those advocacy blinders and then suddenly everybody's blindsided at the mediation or at trial, and now we're back to that discontent Jeannie talked about, where they're, why did I only get $20,000? You told me this was $1 million case. I saw your letter to the mediator. So it's making sure that they're not caught off guard and that they hear that bad news if they have to early and often. And I don't want to get too far away from the issues involving clients, because there's a couple more I want to talk about. But Jeannie, you mentioned something that I think would be worthy of us diverting, because it's another area that I think you both agree lawyers can get themselves in trouble, and that's failing to document or have practice management programs in place that avoid things like missing a statute of limitations, missing a deadline to disclose an expert, things that might be fatal to a case. Tell us a little bit about those.
That's awesome. And that is a lot of the cases I have seen could have been avoided with just a little, maybe I sent this letter, maybe I calendared this date. And I calendared it correctly. I've defended against missed statute of limitations. I have seen, missed expert deadlines. And in legal malpractice cases, 9 times out of 10, in order to prove your case, you're going to need to bring an expert in. And if plaintiff misses it and doesn't disclose, hey, I win. And that's an awesome thing, but I would say you need to have some system in place. And I know that it's harder for smaller firms. I'm in a small firm, it's just myself and Jack. But I have a case list that is my case list, and no one touches my list but me. And I calendar my deadlines and I check them with my awesome assistant who calendars, and we make sure they match. So it's calendared at least 2 places, on the master calendar and then on my calendar. I keep notes on my calendar of what needs to be done. Just so much could be avoided if there was just a little more organization. Emails are a big thing. I had a case where I said, I need your file. And if you are ever sued, when I call you, that's going to be what I ask you for. I want the file for the underlying case. And when I say the file, I mean every single piece of paper that has anything to do with that case, telephone messages and anything, and specifically emails. I need your emails, and I need the emails your client sent you, and I need the emails you sent your client. And what I see is people saving the emails the client sent them in a file, but then they don't save the sent emails. I had a case a while back where I had all the emails that the attorney received, and I called and I said, thank you for these, but I'm missing half this conversation. I need the emails you sent back. And the client, basically said, well, I just saved them all in one big sent folder. All of the emails I send are in one folder for every case. There's thousands and thousands of emails. I'd have to go back through all of them. And, I said, gosh, sorry, but, you need to go back through all of them. So just keeping a separate folder in your Outlook for each case. And then, once a week, I do it on Thursday morning before I start my day, go in and file your sent emails. It just takes a second, sort by subject and file your sent emails. And that'll save you really a lot. It's amazing what you can find in an email.
Right.
Yeah, I was going to say software. It's just so good now. There's just so many options out there. And I've used practice management software since I started, and we're actually about to switch again. But with all of it doesn't. You can get very pricey, or you can just be very simple, like Jeannie was suggesting, just an Outlook kind of a thing. But frankly, with even Microsoft now, the amount of storage you get, there's really no reason to delete things. There's just not. It may cost you an extra $100 a year. It is worth it, because I can assure you, when I've sued lawyers that don't have a file, that happens. They just don't have a file. You're just like, where's the file? And lawyers who, exactly what kind of Jeannie was alluding to was, oh, well, I told them that. If you didn't write it down, you didn't tell them that. That is the way it is. And so if it is not in an email sent to them or something like that, and I've also had cases where I'm investigating, and I asked for the file, and I try to get the other side of it before I even filed a lawsuit, and there it is, exactly what the lawyer said they did. Well, right. There's no case anymore. That lawyer doesn't even need to make a claim on their insurance. We're done. Forget about it. We're done. So I don't need to go any further than that. And so, what a great way to protect yourself from a malpractice suit.
Yeah, and Ben, you mentioned practice management software, but even if you've got a home built system that you just build on Word with folders through your Microsoft programs or through a Mac program, you can just drag and drop those emails, right? Or if you've got a dual screen setup, or you can, each one of them now, especially in Outlook, has a save capability. You can save it electronically to a file, and it'll open right back up. And it's all in one place, and so it's got that file connection that you want.
And even if you're not as diligent as Jeannie is in kind of saving them to the right client type of thing, and you get involved, there are so many companies out there that can just frankly go through your emails and find the emails you sent and suck them all out for a small fee, a few $100s. So the point is, but if you delete them, they can't do that. That company can't do that. So it's just important that you keep that storage there, and keep it as long as you can. Our fee agreement is, we try to keep it for 7 years, but frankly, we just don't delete anything, because you just never know when something's going to come back up and be necessary.
Yeah, with electronic storage, why not, right? It's not like you're keeping all that big paper and tons of tough sheds out in the back of your office.
Exactly.
Let me get back to just two more issues before we wrap up. And these really go back to sort of the client relationship. What about conflicts? Do you guys see any issues for lawyers in conflicts? I'm sure not, right?
Actually, I will say that I see that pled in absolutely every complaint. I have yet to actually see it. I think it's just some lawyers just kind of toss it in there because they think it sounds good. But I have actually never had a case where a lawyer's conflict has been a thing, an actionable negligence, a thing that would cause damages. I know it occurs, but I've actually never seen it. So
yeah, and I think, and Ben, I'll let you talk about what you've seen, at least from my days in the regulatory world. Interestingly, where we saw probably more conflict cases than you would expect is where some personal connection between the lawyer and the client caused the issue. And so, the allegation that the lawyer's judgment was clouded because of that personal relationship. And a lot of lawyers think conflicts, and understandably so, because it's where the rules focus on, client versus client conflict, and sometimes forget that client versus my own interest conflict. And so, back in the regulatory days, we saw the cases where, for example, the lawyer took a personal interest, took an interest in real property for the client, or where the lawyer became a beneficiary of a client's estate plan or something along those lines. There was some romantic relationship between the two. Something along those lines where the lawyer's personal interest was suddenly in conflict. And of course, then when the things were going sideways, now the client's view of the lawyer's interest in all of that was, well, it was a selfish, motivated by greed, and a problem.
Yeah. I don't see, in terms of cases I take on, I haven't seen that kind of exact issue before, but I currently have 2 cases in my office, fairly significant monies at stake, where conflicts are very, very real, and it's in the trust and estates world, where trust and estates lawyers don't appreciate who they're representing. Mm-hmm. And it is a big deal, because what happens is they're representing all the beneficiaries, for example, to a trust, or they're representing a grantor and a beneficiary, and then there is some collision of interests. So that, or they're just way too close to it. I see that as a particularly difficult issue for a lawyer to get around, because at the end of the day, it's going to be very easy for me to find several experts to say, had they had their independent counsel, this X, Y, and Z would have not happened, because they would have been advised differently. So that's where I see a lot of the conflicts of interest coming up. Corporate counsel as well. I'm looking at a case right now in my office that where corporate counsel was hired, probably had kind of as Bill, as you mentioned, a little bit too much of a personal relationship with someone within the company, and that's why they were hired. And then also as a result, knew a little bit too much about the person in the company, but didn't advise the board of what they knew. And so, and it caused significant loss as a result. And so those types of things happen. In the personal injury side of things, where it comes up is representing too many plaintiffs. The car crash where the driver may be at fault. That is oftentimes, even in a like a medical malpractice case, it can be difficult if there's not enough insurance, or there's no insurance. Sometimes that happens. So, or you're under the cap, qualified healthcare provider cap, or a tort claims cap is another one where it can come up. I think those conflicts can be waived. You can possibly represent everyone. However, you have to get it waived, and you have to have a thorough discussion in writing with your client about what it means to have a limited pot of funds and how that's going to affect everyone. Okay. Those are some of the issues. And, we've seen the Leba versus Whitley types of conflicts with PRs and things like that. I mean, boy, I cannot tell you, we handle a lot of wrongful deaths. I can't tell you how often this comes up, where I just had a call yesterday where, mother lost a son. Father has not been involved in anyone's life since they were 2. But if I'm going to represent the PR for the wrongful death estate, they still get a letter, right? And they need independent counsel then they can have that fight. And it may not be a fight. I mean, it may be one of those things where father recognizes, yeah, I don't want anything. But I can't be involved in that, right? That's another kind of very serious thing for the PI lawyers out there who don't quite, they have the call, they have the client contact from a mom or dad or someone like that, and they just don't appreciate that these other folks are out there, and they have you owe a duty to them as well.
And I would just hop in. Sorry. I think that where I'm kind of seeing an issue now with conflicts is actually in engagement letters. So, you can't, you get in a conflict with your client if you want to change the fee agreement halfway through. If this started out as a tiny little PI case and you thought, oh, he or she's got 5,000 in chiropractic, it's not going to be that big. And then lo and behold, it turns into this enormous, fantastic case for you where we're talking, hundreds of thousands or millions of dollars. You don't get to go back and then say, oh, I think I'm going to work on, I want to up my percentage, or I want to change it from hourly to contingent or whatever. That's a conflict. You can't put your needs or your wants ahead of those of your clients. So, if your engagement letter said, I'm going to take this case for you for X amount of dollars, and this plaintiff ends up recovering 50 million, that's a huge bummer for you, but you're really out of luck. The other thing would be like arbitration clauses in engagement letters. If we get crosswise about fees, I want to arbitrate. If you sign this, you're agreeing to arbitrate. You can, or I hope no one does this, but if you do, you can't sue me. If I agree to represent you, you can't sue me. Of course, that's not ethical or allowed.
Yeah.
But that would be a conflict as well. And then, as Ben said, waiving. I would caution that if you're an attorney and if you have any of these issues come up, you need to tell your prospective client that they need to get someone else, get an independent attorney to look at this. If you're going to waive that conflict, that is certainly your right, and you absolutely can do that. But you need to have somebody else look at that. Someone who is not me, someone who's not associated with me, and you need to make sure that you really understand that, because what inevitably is going to happen is the client's going to say, well, yeah, he might have explained that to me, but, I didn't get it. I didn't understand. And I didn't ask because, he's the attorney and I trusted him. So you cannot cover yourself too well, I guess, where that is concerned.
Yeah, and it gets back to that notion, almost where we started, the notion of you're gonna just do something quick for somebody. You're gonna help them out. Maybe Ben in the estate and trust field, it's your pal comes in and mom's passed away, and now can you help me and my sisters and brothers? And all of a sudden you're in the middle of a big fight over the estate, and don't recognize when you're trying to represent everybody their disparate interests. Well, their family. Why is this fight? Holy cow! Why isn't there a fight if they're family, right?
Right.
So let me finish with the one issue that I think we should talk about before we conclude, and that's what about suing your client? Sometimes your clients don't pay you, and so I should get paid. By God, I'm going to sue that client, and they're going to pony up the money. Ben, what do you think about that idea?
I just gave you the thumbs down. That is a horrible, horrible idea. I can imagine some scenario. I'm sure there are scenarios where it's an okay thing to do. In my world, though, that is when I get a call. And I have a war story, a little bit of one where an attorney had a dispute with her client, sued their client over a fee. And I looked, the client gave me a call really to defend against that issue. I looked at the file and said, well, yes, I'll certainly defend you on that issue, but I think there's some bigger issues here that we need to look at. I'm not sure this person was, A, whether they got you the settlement you deserve, B, whether they are practicing in their scope of practice. is the reason they didn't get you the settlement you deserved. And C, boy, these fees are exorbitant given what was the level of skill set that this person had. And so, as often is the case, I actually contacted the attorney and said, hey, I can probably talk the clients into a walkaway if you're willing to do that. This particular attorney absolutely refused a walkaway. And 4 years later, and I really mean 4 years later, she was paying my client a significant sum of money. So, and we didn't pay her a dime. So that is how those go. So I think you have to be very, very careful when you're thinking about suing a client. And I'm not saying that you can never do it. I'm just saying don't throw stones in glass houses, because you better be very, very careful that you have crossed your T's and dotted your I's.
Yeah, what I sometimes tell younger lawyers and law students is something my son loves to quote. This is the juice worth the squeeze. Yeah. And you know what that means, right? Is how badly do you want that disciplinary complaint? How badly do you want that legal malpractice counterclaim? Make sure it's worth it, because that's what's coming when you file that suit for fees.
Yep.
Go ahead, Jeannie.
I was going to say, so if you are going to file a suit for fees against your client, don't do it. But if you feel compelled to do it, you need to know that legal malpractice is a compulsory counterclaim to any claim for fees. So if you sue your client for fees, that is a surefire way to get a legal malpractice claim filed against you, regardless of how good your representation was. It's coming, and now you have to notify your carrier, and now it's just a great big fight. So like you said, Bill, make sure the juice is worth the squeeze. The other thing is, if your client is not paying you, that doesn't mean you can quit working for your client. You need to get that figured out between your client and yourself. You need to just figure out how maybe you're going to withdraw. Maybe you're going to work out a payment plan. But what you cannot do is say, well, I'm going to stop working on your case until you pay me.
And I think that's a really good point in terms of avoidance of this issue, right? I mean, the idea should never be that I'm contemplating filing a suit against my client for fees, right? The idea should be, I dealt with this well ahead of time. And so maybe I lost $5,000, but I saved myself a world of headache with this client because they're just not a great client. Okay. I mean, again, it's the communication. When they miss that first bill, how are we going to fix this in the future? Let's stop. Let's sit down. What's it going to take to get you caught up? Can we do an evergreen retainer now that we've had this issue? Those types of communications need to happen early and often. And you're right. You can't just simply stop work. There are ethical issues concerned with that. But at the same time, you have to let the client know that work can stop at a certain point once you meet your ethical obligations. And so let's get you caught up. But I don't want to be in a conflict with you, client, over fees all the time. That we just can't let it go on for too long. To me, it's just that's what I see is the clients, they just let it go on for too long. The attorney does. It just keeps on and it keeps on and it keeps on and never get caught up, never actually directly address it for whatever reason.
Yeah. And then at that point, not only has the frustration built, right, but you're so far underwater. Now that real temptation to go forward with that suit for fees is starting to raise its head because there's so much money involved.
Yeah. What may have been $5,000 is now $90,000. And that's a different case, right? I mean, you're right. I mean, there is a temptation there because that's a lot of money.
Yeah.
And the judge will let you out of the lawsuit. The judge will let you withdraw. I mean, provided you have met your ethical obligations, that you have continued to work. The judge isn't going to, and depending upon where you are in the case, of course, if it's the day before trial, you're stuck. But if it's early on, the judge will let you out. The judge understands that you don't work for free. But Ben's absolutely right. This needs to be addressed early and often, and you need to bill regularly. And you need to, if your client doesn't pay regularly, you need to stay on your client and work it out however you need to work it out.
All right. Any concluding thoughts, Ben?
Paper the file, communicate, be kind, be nice to your client. Don't be adversarial with your client. I think these are all ways to avoid being sued, at least on my side of it. It's kind of like with physicians, right? if you're nice to your client and even things didn't work out, I don't think you're going to be sued. That's the reality.
Have a good desk side manner.
There you go. Exactly.
Yeah. Jeannie, any concluding thoughts?
Get insurance, get malpractice insurance. If you don't have it, look around, get it. The State Bar's Professional Liability Committee has some really good resources for you to look at. I know there are carriers that offer really available policies. You just need to shop it around. And if you have questions, ask. I've heard lawyers say, well, I do a good job, I won't get sued. I've defended lots of lawyers that have done excellent jobs and still gotten sued. Or I've heard, I don't practice in an area where there are malpractice complaints. I have represented every kind of lawyer there is out there. Every lawyer can be sued, and it just have some protection. There are plaintiffs' lawyers may or may not be swayed by whether or not you have insurance. I mean, if you have severely done harm to a client, they're going to come after your boat or whatever. I mean, it doesn't matter if you don't have insurance. That's on you. So please get insurance. Please paper your file. Please save your emails. And please be kind to your malpractice defense counsel. My job is to do a fantastic job for you, and I think I do a pretty good job. But I'm here to help you. I'm here to defend you. I am on your side. So please just work with me. Don't get mad at me.
If I could add just real quick, first of all, Jeannie does a great job because I've had cases against her and she does an awesome job. I will tell you that. You're welcome.
I'm kind of scared, to be honest.
So going to Jeannie's point is I have currently 2 judgments against lawyers, one for about $1.5 million, I think, another for about $350,000. And we are going after real property. Mm-hmm. They didn't have insurance. One did have insurance, but they failed to make a claim timely. So that's the other part of it. And I think I'd be remiss because Jeannie and I and Bill were on this committee on lawyers insurance. Please, if you think you've committed malpractice, okay, notify your carrier. I see a lot of folks who are nervous. Oh, my rates will go up. Mm-hmm. I can assure you whatever increase in rates you have is nominal compared to the cost that if I am Jeannie, as I am one of those lawyers who, if I take the case on, it doesn't matter if you have insurance. We're going to the end. We're going to get a judgment. I'll go try the case. If you're the lawyer's pro se, it doesn't matter. We're going to the end. Okay. And we're going to see it through. So insurance really is not going to sway me not to take the case on. And in fact, I feel it's kind of my obligation to the state bar and to clients in general to take those cases on and to pursue them. So don't think that not buying insurance is going to save you a lawsuit. It just won't.
Excellent. Well, thank you both. I very much appreciate the time you spent today. I think we've got some great takeaways from it. The good death side manner, document, go get yourself some insurance so you sleep at night, and notify that carrier at the first sign of trouble. All right. I think with that, thank you again to the State Bar, and Morgan, thanks for setting this all up for us. We very much appreciate it. Look for us down the road, and everybody stay healthy and stay well, and we'll talk soon.
Thank you.
Thanks, Bill.
Thank you, guys.
Thank you for listening. This episode was produced by the State Bar of New Mexico's Member Services Department and Lawyers Professional Liability Insurance Committee. All editing and sound mixing was done by Blue Sky eLearn. Intro music is by Kevin McLeod at Incomtech. The views of the presenters are that of their own and not endorsed by the State Bar of New Mexico. Nothing said in this podcast is legal advice for you.